Every word in the Constitution means something, or at least every word should mean something. But the court today just ruled that 6 words in the 14th Amendment are completely meaningless. There is nothing more than repetition of the phrase immediately before it. What am I talking about? Obviously, birthright citizenship. The Supreme Court just ruled that birthright citizenship is guaranteed by the Constitution, and I believe that is the wrong ruling. But I think my reasoning is different and maybe a little bit more reasonable than what you'll hear from any other conservative podcaster online, so stick around. Here's the text of the 14th Amendment at issue. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The whole question turns on that phrase, and subject to the jurisdiction thereof. Today's ruling essentially says it means the same thing as being born or naturalized here. The problem with that reading is that it makes the phrase superfluous. In law school, one of the first things you learn is that every word in a law or an amendment is there for a reason. Today's ruling treats 6 of them as if they do nothing. The phrase has to mean something. The framers wrote a qualifier, and a qualifier has to qualify something. According to Senator Jacob Howard, who actually proposed the amendment way back in 1866, the clause does not include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers. Now, I'll be honest with you. That quote cuts both ways. I read it and think Howard is excluding 2 groups, foreigners and aliens, and the families of ambassadors. But you could read it the other way. You could say the ambassadors line is just explaining what he means by foreigners and aliens. That's a fair reading. I'm not going to pretend that it's not. Howard, by himself, is a coin flip on this issue. So my reasoning doesn't rest with Howard. Instead, I rely on the man who managed the Civil Rights Act of 1866, who voted for the 14th Amendment, Senator Lyman Trumbull. And you don't have to take it from me either, because Justice Alito put it right into his dissent. What do we mean, Trumbull asked, by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. Read that again. Not standing on the soil, not present in the country, allegiance. That's the qualifier during work. That's the phrase meaning something. A tourist owes allegiance to her own country. So does someone here illegally. Under Trumbull's own definition, mere presence was never the test. Now, here's where the online discussion gets it wrong, and where I have to be honest about you with something. When I first read this, my instinct was to say that the court ignored the original meaning, that the framers wrote a qualifier and 5 justices just waved it away. That's the easy take, and it's also wrong, and I'm not going to pretend otherwise. Because the court did do an originalist analysis. The majority walked through the common law. They pulled 1868 dictionaries. They went back to Wong Kim Ark in 1898. This decision wasn't the result of 5 people ignoring history. It was the result of 5 people disagreeing with me about history. So if anyone tells you that the court didn't care about original meaning, then they just didn't read the opinion. But here's the thing. Doing the work and getting it right are 2 different things, and I think they got it wrong. I'm not asking you to take my word for that, because 4 justices, Thomas, Alito, Gorsuch, and Kavanaugh, read the same history and came to the opposite conclusion that the majority did. 3 of them wrote complete dissents. Kavanaugh concurred in the judgment on strictly procedural grounds, but dissented in the constitutional analysis. But their argument is the one that I've been making to you, that subject to the jurisdiction thereof was never meant to cover everyone standing on the soil. It meant allegiance, not just presence. That's the whole ballgame here. The majority essentially says that the phrase is declaratory, that it just restates that if you're a citizen, if you're born here. To get there, the majority relies on English common law, past court precedent, and the plain language of the Constitution. The dissent says the phrase is a condition, that it adds a requirement. The dissent relies on the actual words of those who passed the amendment. Given the choice, I'll take the dissent on that one. Because the dissent makes those 6 words mean something. The other reads them out of the Constitution entirely. So let me be straight with you about where this leaves me. I lost 5-4 on the constitutional question. The dissent did not carry the day, and pretending otherwise would be dishonest. But I lost the vote and I lost the argument are not the same thing. I think the 4 justices in the minority had the better reading of those 6 words and subject to the jurisdiction thereof. And I think that history is on their side. Now, a quick aside here. I think some of the reactions on the right have gone too far. Matt Walsh of the Daily Wire said this opens the floodgates for people to come over and drop anchor babies. But if you think that, you have to answer one question. What did the Supreme Court actually change today? Nothing. The floodgates, so to speak, were already open. Birthright citizenship has been the understood norm for over 100 years. This ruling changes nothing. That leads to the real question. What should conservatives do now? With most Supreme Court cases, Congress can just pass a law to fix whatever they don't like. But not here. The court ruled that birthright citizenship is part of the Constitution, so a statute can't touch it. It would take an amendment. So what do conservatives do? An amendment wouldn't pass. Court packing should be off the table. And we could wait 3 lifetimes before we get a court with enough justices that are willing to change this ruling. So the only thing left is enforcement. Secure the border, increase deportations, and increase federal presence in sanctuary cities. That's the only way to discourage both illegal crossings and birth tourism. Until there's real support for ending birthright citizenship on the Supreme Court, it's the only constitutional option left. And we, as a conservative movement, should remember that every word in the Constitution has to mean something, or else the words mean nothing at all. Subscribe and like the video for more from me. I'm trying to build a brand based on honest, reasonable takes and not the performative outrage you get from so many online these days. If that's what you're looking for, subscribe and head to my Substack to get new releases emailed directly to you. With that, I'll see you next time. Thank you.